Guys, have you ever had something for several years build up to one moment of clarity? I think that we are just about at that moment as the Supreme Court has the Duncan v. Bonta case conferenced for tomorrow, December 5th, where they will decide to take it or to not take it. And, we had this interview with Chuck, you guys, and I just want to let you know we had a little bit of glitches with the camera. Hopefully you can bear with us on that as we continue to be in the dungeon here, but certainly a great conversation to have, looking forward to tomorrow and then potentially the next session for the Supreme Court for the Second Amendment. Let's talk about it. Hey everybody, welcome back to the channel today. That is right, the day is finally here as tomorrow, December 5th, the Duncan v. Bonta case will be in conference for the Supreme Court. And that isn't the only Second Amendment case that will be there. So to walk us through this, we have brought back on the president of CRPA, that is Chuck Michel. Chuck, thanks for being on with us today.
Always a pleasure, guys. Thank you for having me.
Absolutely. And guys, a couple housekeeping items here because Chuck Michel, along with our legislative director, Rick Travis, who I always remind you is on AM 590, The Answer, every Saturday at 1 p.m., have both been nominated for Top Voice in the Second Amendment for the Gundy Awards. We'll put the link in the description below. Let's lift these guys up, everybody. We are doing a tremendous amount of work here in California, which is ground zero for a lot of these laws, therefore a lot of this litigation. So we are doing a lot in this regard. So let's lift these guys up. Let's get some votes in for them. Their advocacy truly is a tremendous effort, not just in the state of California, but as I said, California being ground zero, the rest of the country is at stake. So visit that link. You can vote once a day. Let's prop these guys up and get as many votes in as we can. And as always, please be sure to like, share, and subscribe to these videos. It really helps get the information out as far and wide as possible. Obviously, we are trying to educate as much as we can with some of these landmark cases now at the Supreme Court. It becomes a real big effort looking into 2026 at what the potential could be for the Second Amendment movement, not just here in California, but for the rest of the country. So Chuck, let's go ahead and dive in on this. And Jacob, this isn't necessarily pertaining to tomorrow's conference, but I thought maybe a little context could help us out here, guys. I've got this article from MSN, and it reads like this. With the Supreme Court back in session, the justices are preparing to weigh two Second Amendment challenges. One will look to whether it is constitutional to restrict people from carrying firearms on private property. That's the Wolford case. And the other concerns drug use and gun rights. For the court that's taken less than 24 Second Amendment challenges in its 230-year history, 2 in 1 year is unprecedented. This is a real indication that we have a court that's more willing to and more interested in taking these cases, says Andrew Willinger, the executive director of the Center for Firearms Law at Duke University. The caseload is also a sign that the dust hasn't settled 3 years after the Supreme Court decided New York State Rifle and Pistol Association versus Bruen. A landmark ruling issued in June of 2022 requires modern gun laws to align with historical firearms regulations to be constitutional. Bruen threw the landscape of firearms law into flux, and lower courts have since ruled on nearly 3,000 challenges to gun restrictions, a record number according to the Traces Bruen database, which is now available to the public. So, Chuck, I guess adding this as a little bit of context, because we have talked about the Duncan case, not just in securing the right for Californians to have access to magazines that can hold more than 10 rounds, but another opportunity, a ripe opportunity for SCOTUS to potentially hone in the scope that they tried laying out in Bruen. But before we really dive into those weeds, I'm just sort of curious because we do have this conference. Of course, the Duncan case was conferenced earlier and they took it off conference, and our assumption was, which looks like is what happened, that they kind of wanted to group some Second Amendment challenges together, and now we have a few looking at tomorrow's conference. But how exactly does this work? Are there different levels to these cases being potentially conferenced? Because I think there's like over 40 cases that have been appealed to Supreme Court and are currently sitting in that stage, but only a few are being taken for the conference tomorrow. Can you tell us how this process works with the Supreme Court, with the conferencing a little bit?
Sure. Let me first say thank you for the promotion on the Gundy's Award. It's very nice of you. I hope people appreciate some of the work CRPA and I have done, and we'll get out there and vote. But as they say at the Oscars, it's an honor just to be nominated. So it really is nice that there's some recognition, even if, there's a lot of good players on there. Again, my Oscars speech, there's a lot of good folks on there that are doing a lot for the Second Amendment. They all deserve recognition. So I'm proud to be among them. As far as the Supreme Court goes, there's over 30. So cases, the Supreme Court does not have to review a case. The Supreme Court takes the case. It's at their discretion whether or not they want to take a petition for review that gets filed with the Supreme Court. There's been almost 40 petitions for review filed, including our Duncan case, and the others. There's been two where the petition for review has been granted, and that's the marijuana use as a prohibiting factor case and the vampire rule out of Hawaii case. That's the Wolford case. So both of those cases have been taken. They are being briefed. The United States government actually submitted an amicus brief in the Wolford case. That's a new phenomenon where the United States government is actually on our side. So those two cases will be argued in front of the Supreme Court this term. The other cases have not been granted review by the Supreme Court yet. And what happens is, after a petition for review is filed with the Supreme Court judges get together, typically on a Thursday or a Friday, and have a conference where they go through the cases. They designate a certain number of the cases that have asked for review. And by the way, there's hundreds, not just Second Amendment cases. There's hundreds, and usually only 1 out of 100 will get granted review. But tomorrow they will have a conference, and there will be the Duncan case considered, the Viramontes case, which was the semi-auto ban out of Cook County, Illinois. And then I think it's Gators Guns, which is another magazine capacity case, but that's up there on a preliminary injunction. So the record has not been developed as extensively as it has been in Duncan, because Duncan has been in court for 8 years. So there's a big complete record in Duncan that makes it more attractive to the Supreme Court, because they have that full record to consider when they're reaching their decision. But it's hard to say what the Supreme Court is thinking. They all get a conference. That doesn't mean they're going to grant review. Now, Monday, we should see an orders list where they either grant review, deny review, or postpone the case. And that could very definitely happen. They might just postpone all these cases. And they might have, like a super Second Amendment case day conference where more of these cases, they dismissed a lot of prohibited people cases. They denied review on a lot of prohibited people cases a week or so ago. So it just remains to be seen. Meantime, I have all my fingers crossed to get our Duncan case accepted. But there are other cases pending too. There are some that there are full-on AR, the so-called assault weapon cases. And the Supreme Court, they're going to pick some, hold some, deny some. It's hard to say how they're going to go, but Monday we should have a better idea.
Well, fingers and toes crossed on this side, especially for Duncan. This one means a lot to us. It is a long-standing record for sure. This word unprecedented, we seem to be using a lot this year. A lot of it in the context of the Federal Department of Justice acting on behalf of gun owners, which is great. We see it used again here just in the context of a couple cases being taken in one session by the Supreme Court. And I guess the definition of unprecedented is the definition, but I guess the question is why? Why is it that we are seemingly in an unprecedented time here with the Supreme Court? Do you from your perspective, is it just because we now have so much anti-Second Amendment legislation that's become law? Did we not have this much to battle against, 50 years ago? Why is it that, or is it the nature of the current judges that we have? Why is it that the Second Amendment seems to be getting a lot of attention by the Supreme Court now?
Well, I mean, it's both. The Supreme Court now has at least five and maybe six at least inclined to be pro Second Amendment justices. And so that's, how we got Bruen. That's how we got Heller first and then Bruen. And that's because of Trump's appointees on the Supreme Court. And the reason that we have some good results in the lower courts is because of Trump judges being appointed. But despite the fact that the Bruen methodology, the way you're supposed to judge whether or not a law is a Second Amendment violation, was laid out pretty clearly in both Heller and Bruen, the lower courts have really been twisting that. Now, I think this is the kind of thing that the Supreme Court likes to slap down, to clarify, not let these lower courts get away with this. Frankly, I think, though, that they are somewhat distracted by all the Trump litigation and all the Trump cases that are coming in front of the Supreme Court on the shadow docket. That's the emergency docket. It's not even full briefing. So they've kind of been preoccupied with that. But as far as why this is unprecedented, it's because there's been this critical mass of cases that have come out since Bruen in 2022. And now we have Harmeet Dillon and Pam Bondi and these federal government employees, leaders that are following Trump's philosophical inclination to support Second Amendment rights. We just got news 2 days ago that the Department of Justice, the U.S. Department of Justice, has created a Second Amendment protection division, basically, to really look into these things and make sure that some states are not defying the Supreme Court precedent, which they are, especially in California, especially in the en banc panels, which is why we are now in front of the en banc panel in the Ninth Circuit on the Rhodey case, the ammunition background check case. And depending on how that case comes out in the Ninth Circuit, that will probably go to the Supreme Court. Although, you never know how all this stuff is going to come together. The Supreme Court might just hold all these cases, and then they could do what they did on Duncan the first time it was in the Supreme Court, which is grant review, but not do all the briefing and the hearings. They just vacate the lower court decision and they say, reconsider it in light of our most recent decision. They did that with Bruen. They sent it back. They said, reconsider it in light of Bruen. And that's why we won in the district court. We won in the 3-judge panel. Then we lost in the en banc panel because the judges didn't faithfully apply Bruen. So whatever case comes out of the Supreme Court, whether it's a black rifle case or a magazine case or a prohibited people case or a prohibited places case like Wolford, if they clarify what's covered by the language of the Second Amendment so that these lower courts can't dodge the first step, the first inquiry, which is it an arm, a bearable arm, and is it related conduct to bearing arms, like going to the range or hunting or whatever, what they say in whatever case, in whatever context, could help us in all cases, in all contexts.
Which is kind of the prominence that we've talked about with the Duncan case, right? Or the potential that the Duncan case has. I'm sort of curious, from your vantage point, do you see that being more likely in some cases than others? And what I mean is, do some cases present a larger opportunity for the Supreme Court to do something like clarify Bruen or create that precedent, that newer precedent that the lower courts would have to adhere to? And the reason I ask is because we kind of talked about this already with the Wolford case. They came out pretty straightforward and said, here's a couple of questions that need to be answered in this lawsuit. We are only focusing on this one, which is the carrying on private property part. It wasn't the other part. So from where you sit, does it seem like there's more potential in some cases than others to actually do that as the Supreme Court? And if so, is Duncan the only one, or do you see that potential in others as well?
No, the court, there's a bunch of factors that the Supreme Court considers in deciding whether or not they take a case. One is whether there's a circuit split, like there's differences of opinion in the lower courts on what the answer to a legal question is. Then the Supreme Court gets involved to resolve that. That's one of their primary missions. But they also look at the facts of the case. They look at how extensive the record is. They look at what the issues are. And so in Wolford, the vampire rule case, where the Hawaii state law requires private property owners, like a retail store, to post a sign that says guns are allowed here. And legislatures passed that because they know nobody's going to post that sign. But there are other issues in the Wolford case that they declined to address. So they're looking that's a narrow issue. So if they can get a narrow issue, which is one of the reasons I think that Duncan may be more attractive than a full-on semi-auto case, there are cases where laws where they ban the rifles and the magazines. That's Illinois, and the laws are not. The laws are together. The challenge is to both. And so the Supreme Court might look at Duncan and say, well, we can resolve the magazine issue. We don't have to wade into ARs. But then Kavanaugh said in one of his last opinions, where they turned down a Second Amendment case for review, that it's inevitable that they have to take an AR case this session or next session. And so, are they looking at this like they want to address both the semi-auto rifle question and the magazine question in the same case? Potentially. That just raises more, some separate issues. So that's, one of the factors that they look at in deciding whether to take. Those are a couple of the factors they look at in deciding whether to take a case.
But then once they have that case, there is the opportunity for them to either expand or contract on the scope that they laid out in Bruen for the lower courts, or not really address that at all and very pointedly answer a question specifically from that lawsuit. I guess I'm just sort of curious, do you see some of these lawsuits better at advancing the scope than others?
Well, they still have to go through the methodology. They still, in any case, any Second Amendment case, they have to go through the Bruen methodology. Question one, is it covered by the language of the Second Amendment? Is the right to keep and bear arms, that language, does it cover the law or the conduct? Now, that's pretty clear in a hardware case. Is a magazine an arm? That's what the Duncan en banc decision said. They're not. They're not arms. Well, of course they are. They're an integral part of a firearm. And a firearm itself, like an AR, is an arm. For that matter, a full auto is an arm. That doesn't mean it passes the actual test, which is the historical tradition test, but it certainly gets to that point. And a lot of courts have been dodging that by simply saying, well, we never get to this historical tradition question because it's not covered by the language of the Second Amendment in the first place. The Supreme Court's going to have to say in the two cases that they've taken and a bunch of the other cases that they may take, that the Second Amendment does cover this hardware or this conduct. If they clarify that most things are covered by the language, that's a huge step in the right direction, because that forces all the other lawsuits, that forces all the other courts to address the real test, which is whether or not there's a historical tradition of regulating in the way that the modern law regulates. And then they're going to have to look at what are sufficient historical analogs, laws from back at 1791 or 1865, that's another debate, that show that the founders would have tolerated the modern day law. So no matter what case they take, they're going to have to go through those steps, and going through those steps is going to provide more guidance on what those steps involve and how they should be applied in other cases.
Well, I think if one thing is clear, further guidance is warranted. Further guidance is what the Second Amendment community is looking for out of SCOTUS. It's always a good thing, say in the Duncan case, if it were granted, to get the favorable decision on the 10-round magazines, but further guidance on how these courts view these Second Amendment cases is definitely going to go above and beyond for the future. So, Chuck, I guess
the Supreme Court knows. The Supreme Court those judges know that they got to clean this up. They're watching the shenanigans that the lower courts are pulling to try and avoid having to strike down what is an unconstitutional gun control law.
Right, which makes these cases all the more prominent for us. So we go into tomorrow, we take a deep breath, and then we hold it until Monday to see what comes out on the order list. We are also just kind of on the heels of something else that was kind of unprecedented. You had the Snope case go through, I don't even remember how many conferences. It was like 11 months or something like that. Ocean State Tactical was right along there with it. you don't really expect to see any case go through that many conferences without being either accepted or denied. I guess always we're going to be hopeful to have an answer on this on Monday. It could go through a few. What is that? What are your expectations there looking forward towards next week and potentially the conferences thereafter?
Well, if I was a betting man, I would say they're going to postpone it another time and consider whether to grant Duncan when they're considering whether to grant other semi-auto rifle cases, or I think there may even be another magazine case up there. So I think they're going to want to consider it as juxtaposed against some of these other cases and see which one they think is the most likely. But I'm also hopeful that even if they don't pick Duncan as the primary vehicle to decide things, they just hold on to it. They issue another case like they did before with Bruen, and then they GVR, they grant, vacate, and remand the Duncan decision back down again to the en banc, to the Ninth Circuit, and say, look, we've just clarified magazines are arms. We've just clarified in this other case what a sufficient historical analog law is that establishes a historical tradition of regulating in this area. So now apply again the logic as we've clarified it. But I hope they're just tired of this baloney, and they just say, we're going to take a few and put a stop to all this judicial resistance, which is going on in the circuit courts, especially in the Ninth Circuit, but also the Second and some others, and make sure that they understand how to do a Second Amendment judicial review, and that the Second Amendment has teeth. And there's a lot of laws that are going to be struck down because they are a Second Amendment violation.
Yeah, I think if I was a betting man, I would say that there is at least one person sitting on that bench that thinks exactly that, and that is Justice Clarence Thomas. So I guess, guys, we go to bed, we wake up tomorrow, and we do take that deep breath. Chuck, I know you're a busy guy. I want to thank you very much for coming on, explaining this with us, and hopefully we can have you back real soon to talk about the order list. I appreciate you coming on.
Absolutely. Happy to come on anytime you want. And folks, if you're watching this, CRPA is out there on the front lines in California and also across the country, because a bad case or a good case in another jurisdiction helps or hurts us here. So we have to watch the whole national landscape. CRPA gets great nonprofit rates for its legal work, but it still takes time and that still costs money. So the support that you guys can give to the CRPA to keep fighting these fights on your behalf and making judicial history, legal history. Every dollar you kick in makes you a part of that history. It's going to set the stage for the Second Amendment freedoms for not just our generation, for generations to come.
Absolutely, and I truly do appreciate it. And guys, as always, please be sure to like, share, and subscribe to these videos. Really helps get the information out there. It is a great way for you to directly contribute to these efforts. And hey, if you are just now joining this channel, just seeing this for the first time, and you don't really know what's happened in 2025, we are about to kick off our end of year 2025 wrap-up videos. We're going to go through the legislation, we're going to go through the litigation, we're going to go through the advocacy efforts, and we're going to go through some other things that were unprecedented in our time, like support from the Trump DOJ. So guys, watch out for these videos as they come. Definitely hit that notification bell so that you are notified as these videos come out. You can watch them and become familiar with this battle so that we can be as effective as possible moving forward. Thanks again, guys. We'll see you on the next one.